That based on what it is.
Yes.
Well, item 31, 32, and 33. I am the respondent in all the cases here. Some negotiation is going on between the parties, Lordship. So, Lordship, this is the matter.
In fact, Mr. Jimmy, yes, last time when the matters came up on last Thursday, Wednesday, I told you, take it after 2 weeks. You were, the councils were insisting that the matter should be taken up this week. Didn't I tell you?
Yes.
Yes, last time there was a mention made that Mr. Jimomi is not there. So I said, let it come up after 2 weeks. But it was mentioned, no, we want it next week.
Could we some other matter?
No, these are the
No,
three
it's
matters.
this matter. I think one junior has mentioned.
Maybe there was some communication there. Otherwise,
It's a matter pertaining to the church, see if they wish to compromise and also so.
It has been submitted by the councils appearing on behalf of both the parties that some talks of compromise are going on between the parties and therefore seeks for an accommodation. This matter again,
last week of April,
13th May.
Lordship. Again, Lordship, item 27, this is for hearing. This is a criminal appeal. Let this matter be taken up after 2 weeks. Though.
The request, your person is inside.
Yes,
At the request of Mr. Siti Jamil, the matter stands adjourned to be listed on 20 May 2026.
please.
Please, your lordships.
Yes.
I'd like to mention item 24 and 25, your lordship. In this matter, the state council is Kiandale. And as he is in very your lordship, I pray this matter be listed after 2 weeks.
At the request of Ms. S. Mary, both the matters, the Mary, the learned PP, no? You're PP.
Yes, your lordship.
PP, the matter stands adjourned to be listed again on 8th of April 2026.
Lordship, thank you, lordship. Lordships, I have a single record of 28, 29, and 35. Same council for the state respondents.
Same order.
Grateful, your lordship.
There is lordship. My lord, Appellate Commission item number 26 on behalf of Wisdom Mobile, my lord. Thank you, my lord. I'm informed that his son is not feeling well, that is why he could not come today. Let the matter will come up next week, my lord.
Let the matter be called again on first. Madam, same order, put his name on first.
Much of that.
For admission, item number 1.
Mr. Jimomi, I think we can close this petition.
Yes, my lord.
Because as of now, I still remember for the very cold morning when Mr. Justice Sato told me that it is horrible traveling from Imphal to come to Nagaland, and the area from Imphal to Mao Gate was good. From Mao to Kohima was horrendous. So we took up this matter.
Yes, sir.
But I'm told now the constructions, they have done it.
Yes, sir.
It is not for us now to look on a day-to-day basis. It is makes no sense.
That's right.
Has the affidavit been filed by the,
Yes, my lord. Yes. There is an affidavit which has been filed and it's very interesting affidavit.
Where?
What should I read with that?
some affidavit filed today when?
Filed yesterday.
Yes,
Paragraph 4, it's about the 7 sinking zones and book order issued for 4 of the sinking zones. And paragraph 6, my lord. Paragraph 6. So if I may suggest, my lord, we are maybe closed with the rider that if necessary can be removed.
ah, I think that is the best way, because to continue with the sumoto means it would not be proper. Heard Mr. H. Mumi, the learned amicus curiae, who appeared on behalf amicus curiae. The director is here,
Yes, sir.
Mr. R.P. Singh, the executive director of the NHIDCL. Mr. N. Mujoy, the learned counsel appearing on behalf of the respondent number 13 and 14. Mr. Santianger not there. Mr. Who is there? You are there. So and so appearing on behalf of the respondent number 10. And Mr. I. Im Song, the learned counsel appearing on behalf of the respondent numbers 3 to 7. Pursuant to the order passed by this court on 18/3/2026, an affidavit has been filed.
Cynthia, you're also here in this
Yes,
case.
I'm going
You
to
were
that
there
after meeting here.
on 18/3/2026. An affidavit has been filed on behalf of the respondent number 2 and 8 by the Executive Director NHIDCL, Nagaland, wherein it is mentioned that with regard to the maintenance of repairing of the section of 100-meter stretch road near Pesama/Kisama at chainage 191 plus 950 to chainage 192 plus 080, work had been completed and vehicular movement is presently smooth and motorable. It is also mentioned that for restoration of 7 sinking zones, which have been brought on record before this court, appropriate steps are currently undertaken. Amongst the 7 sinking zones, 3 have been identified as priority sections for which 5 work orders have been issued for emergent repair works. And presently, the work is in progress. It is also mentioned that the said work is not affecting the traffic movement. It is also mentioned an undertaking has been also been given at paragraph number 5 of the said affidavit that during the monsoon season, the landslide clearance would be done immediately as and when required to avoid disruption of traffic for road commuters, and the road will be kept in traffic-worthy condition. Further to that, it is also mentioned that for the existing Kohima Mao Road, the DPR is under preparation, which includes slope protection of hill/valley side of the road, along with strengthening of pavement of the existing road. It is also, first of all, that said the DPR consultant had also, and the DPR consultant would be submitting the final DPR by 30/6/2026. In the backdrop of the above, we find it very pertinent to observe that by an order dated 2/3/2022, taking into 2000, we had initiated the instant public interest litigation, sumoto, taking into account the deplorable road condition from Mao Gate to Kohima. during the passage of time, there has been various works carried out, and presently it has been submitted that the work in the road stretch from Mao Gate to Kohima is in roadworthy condition. We have also taken note of the affidavit which have been filed, the affidavit, the details of which have been already referred to herein above. Taking the above, taking into consideration that the presently the road from Mao Gate to Kohima is in roadworthy condition, we do not feel that there is any requirement for regular monitoring by way of the present public interest litigation. Accordingly, we close the present public interest litigation. It is observed that the closure of the instant public interest litigation shall not affect or preclude any citizen to again approach this court in the circumstance and necessity arises in respect to the road stretch from Mao Gate to Kohima.
Item number 2.
Yes, Mr. What is this matter about?
Lordship, this is about National Highway 329A. This is the second PIR on the same deal. My lord campaigns, the order dated 10/12/25. 10/12/25. The last paragraph, paragraph 6.
Yes.
The Learned CGC representing the MOD, URI is to ensure that its decision-making process and on the decision on the DPR pertaining to National Highway number 329A is placed before this court on the next date of the stay. So this was the variation. After that, instructions are yet to be placed before this honorable court.
Why? What is the matter about?
National Highway 329A, there was a direction that the state should be constructed within a period of 3 years. So since that was not constructed, the second period was filed.
Okay. Oh, there was a direction passed by the court.
Yes, come.
In the PIL dated, in the order judgment dated 17/11/2021. Now that has not been constructed.
Not yet. And this manor is the alternative road. Whenever National Highway 29 is blocked, or should have been on that road many times.
Which
the
one?
road From that, Shofti, ARTC,
Uh-huh.
and goes uphill and then comes out to Janapani. This is that road.
Okay.
Mr. Lordship, I will grant on behalf of my senior, Gauhati, learned citizen. Lordship, in this matter, despite several reminders sent to the ministry, we have not received any instruction till then.
This is in violation of the order passed in the PIL. This is taken suo motu? No.
No man.
Why are you not filing a contempt? I think you file a contempt. Then only they will come in. You see, otherwise this, you see the order of 10/12/2025. At that point of time also, the CGC is not appearing. And resultantly, the matter has not progressed. And when a notice has been sent from here, they are not responding because NHIDCL cannot do anything, taking into account that the MOT is not taking any action. So this is a violation to the order passed here. I think we better file a contempt.
On top of the state is
Is this under the, no, is it under the state PW? No, it is not. Is it under the state NH division or NHIDCL?
Only the maintenance. It was a maintenance contract, and for that purpose, it was given to the NH under the state. So maintenance part is not it, but the actual construction, that, nothing here.
That is for widening.
Yes, sir. That's nothing done.
Problem is, as I was taking up yesterday, some matters. The problem is because who is going to pay the land compensation? Is the biggest
In
problem.
not a single case that has been done. In all these cases.
Because yesterday I passed one order in one of
Yes.
the matters out there from, I think, Futsara to FEC. I think there seems to be something required to be done by the state or give a have to take into account one thing, that how will the right over the land be vested upon the state? Because you cannot have that land. They cannot just take away. And without the DPR, another problem which we have to see out here, we can very well say that, okay, if a road is bad, but can the High Court direct that the road be widened?
Construction, since it was declared,
Ah.
since it was declared,
There is no construction
no construction,
till date.
till date.
My lord, I wish to. Plus this.
Directed to construct, expand and maintain.
This one.
DPR is yet to be declared by the Ministry of Work and Development. They has taken this step, but more TH is given. And more. DPR.
Can I give a little background?
Please.
So National Highway 129A was first notified. And National Highway 129, the work order was issued with a description which was given by the board. Only board can give a description, my lord. What the NHIDCL did was it deviated from the description. And the portion from Vimla Junction to Mahinam C, that is the uphill section, which is the diversion which we take when National Highway 29 is blocked. That was left out. For a lot of reasons. So I came to this on board, finding a PI saying that is not a finding. The NHIDCL as the implementing agency cannot deviate from the description of the National Highway 129. During the pendency of the petition, the excluded portion was brought within National Highway 329A. And so therefore that direction was kept.
Okay. So it was already there in the DPR
Initially in 129A.
initially.
Yes. Then for reasons which need no explanation at this point of time, that portion was excluded and the highway was deviated by the NHIDCL, not by the north. But since the excluded portion was brought into National Highway 329A, the Honorable Court came to the conclusion that there is no matter finding. National Highway, that portion has now been brought into 329A. Therefore, 329A itself should be constructed within 3 years.
And
That was the background.
that direction was given to whom?
The Mort as well as the state. But since it is a national highway, my lord, primarily Mort.
But it was already the decision of MOT
Yes, it was a decision.
to construct it there, as it was
Yes,
site
yes.
129A. And now they have renamed it as
No,
329A.
129A itself is there. The excluded portion.
Now they have renamed as 329A,
329A,
and that is the one which has not been
which
completed.
is not used. And National Highway 329 includes, it starts from the Difu border this side, my lord, on the Rangapur side. From the Difu border to Sankam Tila and all the way to Painamsi Junction.
Here it is from Santamtila near Assam border
Yes.
to my
Mahinam Yes.
on NH here. Tentative is 45 kilometers. And why do they say is supervision of upgradation of existing intermediate lane to 2 lane?
That was a contract which was awarded to the the execution of that part, maintenance, upgradation was given to the National Highway State.
So therefore,
That was different.
we have a road which
know.
is single,
Yes,
not two-way.
no,
And this is the direction which is passed on
1711.
1711.
subdivided.
Where can we have the judgment?
Judgment is at page 17, my lord. Of my resolution, page 17. And the operated code 44. In fact, from page, paragraph 6. Paragraph 6. What we come to the last portion. Take the last paragraph 6 at page 40. Take the last sentence, my lord. Therefore, we are also of the view that both the central and state governments have no intention of leaving that stretch of land unattended or uncared for. In fact, two national highways have been created in and around the same area of the state. Therefore, we find no reason to suspect any malafide involved in the decision-making process. And page 41, the last paragraph. However, taking into view the anxiety and concern of the public, particularly villages, whose villages are located along the earlier unified stretch of 129A, which is now 329A, we direct for the Union of India, particularly in the issue of MRTH at the government of Nagaland, to construct, expand, and maintain National Highway 329A as any other national highway, and it should be done at least at the earliest, but not later than 3 years.
Now, the government does not file any affidavit. Respond number one has
Government is
filed.
fine. That's fine. Government is fine.
No, who is respond number one?
So the union will.
What do they say in their affidavit?
The. No. Fine.
About respond number one, yes, what do they say?
Union of India is not fine.
Union of India, has filed.
Respondent one is filed.
They have filed. You have filed the reply against that.
Yes, madam. And the union says that it will construct.
Kindly come to paragraph 5, page 5 of that.
Page 5.
Yes. So number 3, to widen the existing intermediate lane to 2-lane with paved soldiers have invited. This affidavit was filed as far back as on 23/4/2000. It was filed on 11/4/23/4. Anyways, it was filed on 23/4. 23/4 it was filed. So therefore, the state has nothing to do here. The central government has also invited, currently bids are under evaluation. This is the status.
Yes, madam.
So after this, what has happened? 1 year has gone. Central Government Council is not here.
You have some personal difficulties too.
It can't happen like that. 2 o'clock, let's see the person, the deponent on the video conferencing line. Call him up. He's in Gauhati. We'll provide the link. This can't happen like this. 1 year, how can it happen? There's an order passed on 10/12. Because from here it appears that the directions which was passed by this court have been complied with. But what is the problem is that we are not getting anybody from the instructions from these authorities. Let's pass an order and have it on the next week. We are not concerned whether Mr. Yangawati appears or not. If we don't get the instructions, we are going to call the secretary moot next time. Heard Mr. H. Momi, the learned counsel, appearing on behalf of the state respondents, appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent number 1. Mr. L.T. Santam, the learned additional AT, appears on behalf of the respondent number 2, 3, 4, 5. Mr. Muajami, you appear where? Mr. Muajami appears for respondent number 6 and 7. The present PIL have been initiated, have been filed. Alleging that in spite of the judgment and order dated 17/11/2021 passed in PIL number 3/2021, no steps have been taken by the authorities concerned for the purpose of expanding, maintenance, and repairs of the National Highway 329A. Taking into account the allegations contained in the instant public interest litigation, this court finds it pertinent to reproduce paragraph number 6 of the order passed by this court in PIL number 3/2021. Madam, you will find it at page 40 of the public interest litigation. It is further seen that in pursuance to notices issued in the instant public interest litigation, an affidavit has been filed by the respondent number 1 on 23/4/2025. In the said affidavit, it is mentioned that NH 329A was declared as National Highway connecting Diffu in the state of Assam to Pimla Junction in Nagaland via Santam, Santamtila, Santamtila.
To Mahinam
Huh?
up to Mahinam.
No, this is what they are saying in the
It
affidavit.
was corrected, my lord. It was corrected. So I brought it to notice of this on the
No,
court.
it's okay. Mr. Jimumi, what they are saying, let me put it out there.
Very well.
From Santamila DPG, DIZEDPHE, and Kieto on 28/7/2016. It was further mentioned that National Highway number 329A was entrusted to the state government of Nagaland by Gazette notification dated 23/12/2016. And the length of National Highway NH 329A in the state of Nagaland is 45 kilometers. It was further mentioned that the proposal for entrustment of NH 329A to NHIDCL was submitted by the state government of Nagaland to MOT on 12/3/2021. And in anticipation, NH 329A was handed over to NHIDCL for maintenance on 26/3/2021, even though no formal entrustment was notified. Following the takeover of the stretch by the, the affidavit also mentions that following the takeover of the stretch by the NHIDCL, work was awarded for construction of the intermediate lane with hard shoulder on NH 329A from Santamtila to Pimla Junction on 23/6/2021, leaving Pimla to Maimansingh section, which was then NH 129A, which was later declared as a part of NH 329A, It was further, however, as the road was not entrusted formally to the NHIDCL, even after a lapse of 1 year, after completion of the work, the stretch was handed over by NHIDCL to the state PWD in May 2023. The state PWD thereupon submitted a performance-based maintenance estimate to MOT in November 2023. However, the sanction could not be accorded in financial year 2023-24 due to paucity of time and declaration of the model code of conduct for the Lok Sabha elections. It is further, the statements made at paragraph number 3G of the affidavit filed by the respondent number 1 on 23/4/2025 is of relevance, and the same are reproduced hereunder. Adam, page 4 and till page 5, annexure 3. This is mentioned. From the above quoted paragraph, it is seen that repairs have been carried out as stated by the respondent number 1. It is further Insofar as widening of the intermediate lane road to 2-lane with paved shoulder configuration, bids were invited on the basis of a notice inviting tender dated 8/11/2024. Pustak. The record further reveals that thereupon nothing has been placed before this court as regards what happened in pursuance to the bid, the notice inviting tender issued for the widening of NH for converting the intermediate lane to 2-lane by the notice inviting tender dated 8/11/2024. We find it, we have perused the records and more particularly the observations made in the order dated 10/12/2025, wherein the learned CGC was asked to place before this court as to the outcome of the said notice inviting tender dated 8/11/2024. Today also, when the matter is being taken up, it has been informed to this court by so-and-so, appearing on behalf of the respondent number 1, that they have no instructions. From the above, we are of the opinion that not placing the instructions as have been sought for on 10/12/2025 appears to be undermining the rule of law. We give a final opportunity to the respondent number 1 to provide the instructions as regards the outcome of the notice inviting tender dated 8/12/2024, as well as what further actions have been taken for the purpose of converting the intermediate lane to a 2-lane in NH 329A. We have fixed the list the matter again on when can you get?
Project 2 weeks. 2 weeks.
List this matter again on 15th of April 2026. On 15/4/2026, we observed that in the circumstance, the instructions are not placed, we shall be constrained to pass appropriate directions.
Item number 3.
Hello. I have instructions to withdraw.
Anyways, for your convenience
My lord.
and for your better knowledge, let me give you some judgments. 2024 2 SCC 362. Paragraph 16,
3-6, my lord.
2. Paragraph 16. 2024 7 SCC 715 315. Paragraph 110. And 2021 3 SCC page 1, paragraph 2. The last one is a constitution bench.
Lord, sir.
Okay.
My lord, we close that one.
Mr. Sentienga, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would not like to further press the instant review application. Accordingly, the review application stands closed on withdrawal.
We close that one.
Item number 4.
Respondent two is not represented. Respondent two is not represented.
You are appearing for response number 2.
No, I'm for the appellate document.
Then,
Respondent two is not represented. However,
no, we have deemed that the service upon response number 2 is complete.
knowledge.
That is our last order.
Yes, sir.
Now argue.
This appeal is filed against this. The single judge, question and order dated 5/8/2025, Lordship.
Page. Page.
Page 128, Lordship, and it is this.
20, yes. What is the order?
The effective portion is operative portion is at 136. We Lordship, even though it is been disclosed, our main players will not consider it Lordship and
What is this order?
Lordship,
Against what?
against,
Nagaland Information Commission.
yes, Lordship.
Then what is there? What is the information you sought for?
Page 54, Lordship. This is my
54.
application.
Yes.
Uh,
What do you want? The decision
Number two.
taken during the consultative meeting on the land issue of Old Dow Complex Waka on Iman under the chairmanship of Agriculture Commission as clearly stated in the office notification. So and so. You wanted that,
Number
the
two,
decision. You got that
Committee report.
with all relevant documents and cadastral survey as directed by the office notification dated so and so. You wanted that.
Yes.
And
1 and 2 was denied, but that we have no grievances against that. Actually, but number 2, that was denied to us.
so you are against non-furnishing of number
Yes.
2.
Yes.
Yes, madam, why haven't you given it to them?
Your Lordship, here the committee report was not officially documented. The first committee report.
Right.
So by detecting the anomalies in the first committee report, the second committee was constituted, setting aside the first committee report. So the department has approached the NIC for extension of time. And that was granted by the NIC. So the main challenge is against the findings of the NIC. In pursuant to the NIC findings, the second commission report was submitted and it has been approved by the government.
So take the
So,
second.
yes, yes.
Lordship, the NIC decision, Lordship, operative portion 71, Lordship,
Page.
page 71. Lordship. Here, Lordship, the final authority that we went to, which is the NIC, there this
Page,
issue was
observation, which one?
71,
Query number 2.
the last.
On being asked by the commission whether the committee has submitted its report as decided in the consultative meeting, Sri so and so advocated for the PSC report that finally, yeah, land issue was submitted by the agricultural. However, since eviction,
However, if eviction is involved, he feared that the information cannot be disclosed at this point. That was the
Alright.
information of the department.
Now what does the commission say? Observe that since the final report of the committee was only recommendatory in nature, it shall not fall under the exemptions as there appears no threat or disclosed within the. So after the recommendation of the committee is examination. Time and hence to expedite proceeding. Yes, you are agreed that there is no direction.
There is a direction, Lordship.
A copy of the committee report on the land issue of so and so which was submitted to the agricultural demand shall be furnished to the applicant.
We are not aggrieved by this order, Lordship, but subsequently, at page 76, Lordship, the NSC has modified its own order, page 76. It has modified its this order, which Lordship is beyond its statutory powers granted by the RTI Act. So we are praying that this be quashed and set aside.
You understand this to be set aside.
Yes, this 22nd May by which the decision was modified.
So you mean to say that when there is no power of review,
Yes,
how can they review?
Lordship.
And then this order was set aside by the High Court, single bench.
It was not settled.
So therefore you are before this court. Now let us see what is the impugned order.
The in order of the government Lordship is at page 78. This is the meeting minutes, not the order.
Correspondence will be indeed directed. So your basic case is, there was a direction to provide the report. Review was done without having the power
And without informing us also.
and without informing. And therefore, you have come before the court,
Yes, sir.
only challenging that review.
That review order as well as the minus by which the government said the earlier committee report null and void. The information which we sought was declared null and void.
Why do you need that committee report then?
Lordship, because that is the original report was information we sought for.
That has been set aside.
But Lordship, there was.
The report is within that report by a committee, be recommendatory in nature.
Okay.
They may accept or may not accept. If they don't accept, matter goes. If they accept, yes, in a circumstance that that report had said something by which your conduct or your reputation has been harmed, very well, you may have a right to say so. But the government says that we are not going to consider. How does that report has any? Yes, you see, the order passed by the learned single judge may not be proper. It's a different thing. But does it solve your problem? Because you see, you want a report which the government had, just for example, you ask somebody, okay, go and investigate something. They give it and you are not satisfied. And you say that go again and do it. What is that report going to do?
At this point, whether this is against me or for me, that is the information I sought and I want that information. And it has been discussed at length.
But madam, why are you not giving that report? Yes, it may be set aside.
Lordship.
Are you saying that the government have set aside?
Yes, yes. That has not been-
Interesting. If you're
Your
saying that
Lordship-
no, therefore you are saying that the government have set aside. Means there is a report.
Your Lordship, may kindly come to page 86 of my affidavit in opposition. We are relying on that. However, Your Lordship, before going into the merit, Your Lordship, the impugned order was passed when my ladyship's husband was the chief information commissioner. So whether this court,
Wait, let us see first. Where is the
yes, 86, my affidavit in opposition. Relevant para is para 10, page 91.
the appellate hearing as petitioner. Have assailed the communication dated. The order dated 22/5/2023 passed by the Nagaland Information Commission. Taking into account the same, list the matter before any other court without one of us put ladyship's name.
Item number 5 to 7.
Why are 3 appeals?
Petitions for.
Okay, which one do you want to argue?
They have challenged the termination order. During, under the challenge on the ground that no show cause notice was issued. During the pendency of the petition, you have withdrawn the termination order and then issued the show cause notice. In the subsequent petition, we have challenged. Thereafter, a person who has not joined in the earlier litigation, she has joined. So another petition was filed, so 3 petitions.
So we have to understand the first writ petition. You challenge the termination order
Yes,
on the ground that the same termination has been done in violation of the Nagaland Civil Services Discipline and Appeal rules, as there is no show cause notice.
secondly, another issue was that the Lok Ayukta do not have the jurisdiction to investigate in view of section 9, there is a bar where the local Ayukta do not have the jurisdiction to investigate the cases linked with second schedule of Nagaland Local Ayukta Act 2017. So those were the issues to be
So the
decided.
first writ petition has therefore become infructuous
No, Lordship.
because it was withdrawn. Termination was withdrawn.
Termination was withdrawn, but the issue with regard to the jurisdiction was there. Fish order was issued subsequently. Now, during the proceeding, before the writ court, Lok Ayukta did not participate in the proceeding. And the finding of this, the learned civil judge was that the complaint,
Which matter you want to take first?
first 41.
Is the common judgment?
One judgment, Lordship, yes. So this will cover the other cases as well. The only one problem, Lordship, here. The learned single judge, while arriving to the finding that the complaint before the Nagaland Lok Ayukta was not in the nature of a grievance. That was arrived without any materials and record. In other words, Lordships, what was the complaint? It was not available before the court. Whether it involves a grievance or it is simply a complaint. But without any materials, the learned single judge arrived to the finding that it is an allegation only, therefore, Lok Ayukta will have the jurisdiction. Now, by filing the writ appeal, we have questioned the finding of the learned single judge that look, when there is no materials and record, it is actually the Lok Ayukta who should produce the records. What is the content of the complaint, whether it involves a grievance or not. That is the core area where the learned single judge has found wrong notions. With due respect. So now, in the present proceeding also, the presence of Lok Ayukta will be necessary because they will be the one who will produce the records. And then if it is just simply a complaint, then yes, they may have the jurisdiction under section 10. But if there is anything with a grievance, then there is a bar under section 9 and schedule 2 of the Nagaland Lok Ayukta Act. That is the simple case to be decided by the Senate court. And assistance of Lok Ayukta will be necessary in order to ascertain that because they are the custodian of the records. Notice was issued by the Senate court and on 11th of December 2025, we have also taken steps by registered force also.
It has not been admitted.
Not yet.
Now tell me what is wrong with the order?
Finding is lordship with paragraph 12,
Kindly come to paragraph 17.
12, 13 and 14 lordship, the finding.
Yes, what is wrong with the?
Page 1, 2, 3.
Yes,
These are the 3 paragraphs where the finding has been arrived by the answer.
let's come.
May I read from paragraph 12, page
Yes.
1, 2, 3.
Yes.
A perusal of the provisions of section 9 of the Act of 2017 would reveal that the Lok Ayukta or the Upper Lok Ayukta, as the case may be, shall not conduct any investigation under Act of 2017 in cases of a complaint involving a grievance in respect of any action specified in the second schedule or where the complaint has any remedy by way of proceeding before any forum or authority. Clause T of the second schedule to the Act of 2007 mandates that an investigation with regard to action taken in respect of appointments, removal, bail, etc., or other matters relating to conditions of service of the public servants would not be permissible to be carried out by the Lok Ayukta. However, other actions involving allegations of corruption in respect of appointment would be excluded from the review of the bar operating under the provisions of Section 9, Clause 1A. Further, a part is contemplated with regard to the conduct of any investigation by the Lok Ayukta or Upa Lok Ayukta, as the case may be, based on complaint involving a grievance in respect of any action. If the complainant has any remedy by way of proceedings before any forum or any other authority. 13. And a close perusal of the provisions of the Act of 2010, more particularly Section 10 of the Act of 2010, it ought be evident that the complaint as contemplated therein can be of two kinds. That is, one, involving an allegation.
Now, what is the 2007 Act?
That is in the.
What is
reflected
2007?
Choose in the judgment. Can we come to page 120, Section 9?
Section 9 is a 17 Act. And what is 2010 Act?
Yes, Act of 2017.
And what is 2010 Act?
Page 120, Doctor.
Understood. Well, but paragraph 13 mentions about some 2010 Act.
Paragraph 13. Section 10 of this is wrong. Doctor. There is
It should be
it must be a
17.
diving mistake. 2000, it should be 2017. And put the sections are reproduced in the judgment lordships. In page 120 to 123. There is a direct part. And lordships are well aware about the object of the Lok Ayukta, also constitution of Lok Ayukta and the Prevention of Corruption Act. These are the acts which are committed in discharge of their.
And where is section 10? Oh,
Section 10,
provision relating to complaints. Subject to the provisions if there are complaints shall be made under this act to the Lokayukta in case of any allegation, any person, and in case of grievance by a person aggrieved. Provided where the person aggrieved is dead or for any reason unable to act for himself, the complaint may be made or continued by his legal representative or by any other person who is authorized by him. Okay, let us go now. Would be evident that the complaint as contemplated therein can be of two kinds. One involving an allegation which can be raised by any person, and the other pertaining to a grievance which is raised by a person aggrieved. A complaint raising a grievance.
and in fact, before this proceeding, the petitioners have applied through RTI. Kindly furnish a copy of the complaint. We have submitted an application, but we were denied also.
kindly come to page 126. Yeah, the
Yes,
said infirmity is noticed to have been appreciated by the government in the department of so and so. And the said order of termination dated 7/1/2025 was kept in abeyance, while issuance of notification dated 20/1/2025. Thereafter, the order dated was stayed by this court in the proceedings in WPC number so and so. The respondents thereafter on nullification of the termination of the petitioner. What do you mean by that? The respondent thereafter on nullification of the termination of the petitioner issued. But it was always
Because what
stayed.
when we raised that in the first state petition,
Ah,
government became wiser that, oh yes, it was supposed to be issued a show cause notice, but it was not issued. So the termination order was nullified by the government.
so they nullified it.
Yes,
When?
yes, there.
They have withdrawn it.
Yes,
Okay, but it was stayed. When the court stayed
Yes.
it, it was withdrawn.
yes,
Then you are issued show cause
yes.
from them to show
And
cause
that
as
was
to
challenged
why
in
their
the
services
subsequent-
should not be permitted as they were appointed without following the due process. Okay, now I got it. So your entire case is that based upon the Lokayukta's recommendation,
Recommendation.
the petitioner was initially terminated
Yes,
by an order dated 7/1/2025 or something. You challenged it.
yes.
Government became wiser, issued the show cause.
Nullified first.
Not nullified first, but issued the show cause.
Yes.
When the show cause was issued, you approached this court.
Yes.
This is your second.
Second.
And what is the third writ petition?
Third one, petition is one of the persons who were terminated by a government order. She was not willing to join with the petitioners. But by subsequent order, her service was also affected. Therefore, she has also filed a petition like the other petitioners.
Challenging the
Despite,
show cause.
three.
Challenging the show cause.
Yes,
Now your grievance is they could not have issued a show cause on the basis of the Lokayukta's recommendation.
yes. Because the Lok Ayuktha do not have the jurisdiction to investigate in a matter like this. Says in view of the bar under section 9 and second schedule.
Now, can't they issue a show cause notice
Independent,
independent?
that is up to them.
No. Can they?
That I cannot say,
No.
but it is up
No,
to them.
I'm not on anything
But-
else. Let's see, this show cause notice is issued in terms with what?
In terms of the recommendation of the Lok Ayuktha.
No, understood. But this is why a show cause is issued. Are they not covered under the Nagaland discipline and service rules?
They are governed by that.
So this is done in terms with 311, the proviso to 311
Framing of the rules.
of the constitution.
Yes, framing of the rules.
And the rules, more particularly rule 9, because if you want to put a major penalty you are to have an inquiry.
Correct.
So irrespective of the Lokayukta's recommendation or not, they can still go ahead.
Yes.
Then why should we stop it? That we can very well say, don't rely upon, we can very well say that, okay, if you have any problem with that, then they can do it independent without the recommendation.
That discretion is there without saying also.
Huh?
But
Why should we interfere with this?
the casualty which has been inflicted on me, the source is from the recommendation of the local.
Maybe,
Basing on that, they have done.
maybe, but just for example,
And
let
that
us,
was-
let
that
us,
was-
no, Mr. Zamir, let us take the case of a case under commission of inquiries. Lokayukta is saying, it is, I have passed one judgment in the case of, I think, Mr. S.S. Day, if I remember correctly. I held that what the Lokayukta can do is only recommendation. They do
Yes.
not have the power to investigate
Yes.
other any investigation or punish. The only is they can recommend and
Yes.
it is for them to accept or not to accept.
Yes.
Now they have initially accepted so much that they terminated it. Later on, they became wiser that you cannot accept so much, and therefore we will issue a notice so that we can have we are the decision makers who can do it. But a commission of inquiry, held under the Commission of Inquiries Act 1952, can also submit a report. Recommendations are to be made. If you go to the various judgments of the Supreme Court from K. Singh, State of the Karnataka, all this case, says it is just recommended. The government may act, may not act.
Yes.
The government have acted. Very well, they can act on that for disciplinary proceedings also, that can be acted. But if it violates your right that you have not been given an opportunity while investigating and no. The Supreme Court said in one of the cases that the report may not go, but the report cannot be used against them. Let them go ahead without touching on the report, without the basis of the report.
Lordship, that will
Otherwise,
be,
they have the power.
Lordship, that will be an independent power without any connection with the recommendation
Absolutely.
of the
Absolutely.
local. Because that was the only issue in the present proceeding. You do not have the jurisdiction, but you have done it on the basis of that recommendation. The government has acted. But we're challenging the source of power of the local Ayuktha that look, we do not have any power to do it.
No, why should we go into unnecessary things as regards the Lokayukta has the power or not? Your primary action first is you were dismissed. That petition has become infructuous, taking into account that you have been reinstated and they have issued a show cause notice. So
No,
that petition.
that show cause notice is on the basis of the recommendation of the local.
No, that has come subsequently. First, you were terminated.
Yes.
Termination has been nullified. So that petition has gone, it has become infructuous. You may have raised many points, that's a different aspect. But that petition, your primary grievance was you were terminated. That is why you have come. That is the moment the termination is withdrawn or the termination is nullified, that petition has nothing in it. Let's see the second petition out here where you, and third, you have challenged the show cause notice. Your grievance is they have issued the show cause notice on the basis of the recommendation.
Yes.
My question is, do they have the independent power also to issue a show cause? Yes. Only your grievance is they should not rely upon the recommendation. Okay, they can very well go ahead independently. Matter over. Yes. Let them go ahead without me. I'm giving you all the relief what you are asking for.
Without.
And Mr. Angami would not mind going ahead without insisting on the recommendation.
Yes, yes.
You have the independent power.
Yes, yes.
And you are also, that investigation which has been done or the recommendation shall not be taken into consideration while deciding the so-called.
Correct.
Over.
Lordship,
Not over.
this honorable court, I believe, may not advise the government.
I'm not. I'm.
No, but when this should-
Mr. Jami, I'm not we are not advising. We are saying, we are in fact saying in your favor and saying that you go ahead, whatever you feel like, but don't.
The
Don't,
recommendation of the
no,
local
no,
health act.
don't decide the disciplinary proceedings on the basis of the recommendation. That is what they have to then take into account other materials. They may use the materials which are inside, but they can't take the recommendation.
Yes.
That is already there from beginning, but they have, again, no course. That power was already there with them,
That is why
and I cannot stop them also.
you cannot stop them.
But they have taken.
No, just for
no-
example,
no approach.
no, because today I set aside also the recommendation. Why need I set aside? When the government may accept or may not accept. But the fact remains, all these things, whatever, they have an independent power. Let them go ahead.
Correct.
And we will take only his submission to that effect that they are going to do it independent of the recommendation.
Yes.
Matter over.
Yes.
Win-win.
When not only in my case, but in case of.
Wait, he's giving a concession.
Oh, yes, yes.
He's giving a concession for you. So we dispose of the thing.
Lordship.
I bless the city.
Yes, sir.
Yeah. Because one has already become infectious.
Lordship.
Heard Mr. Chiti Jamir assisted by the senior counsel, assisted by so and so, appearing on behalf of the appellants in the present batch of writ appeals. Mr. N. Angami, the learned counsel, senior government,
Yes.
the learned senior government advocate appears for the state of Nagaland. The present batch of writ appeals have been filed challenging the judgment, the common judgment and order dated 24/11/2025, passed in WPC number 3/2025, WPC number 17/2025, and WPC number 18/2025. Full stop. Before deciding the before deciding as regards as to whether the instant writ appeal is required to be admitted, we find it necessary to note down the brief facts in the three writ petitions. The petitioners in WPC number 3/2025 approached this court challenging the proceedings initiated by the Nagaland Lokaयुक्त in complaint case number A.NLP-40 of 2022. Semicolon. The order dated 16/7/2024 passed by the Nagaland Lokaयुक्त Kohima, Nagaland. Semicolon. The letter is dated 26/7/2024 by the Nagaland Lokaयुक्त Police, Nagaland. Semicolon. The letter dated 20/12/2024 by the Joint Secretary to the Government of Nagaland in respect to the petitioners, as well as the termination order dated 7/1/2025 passed by the Director, Directorate of Employment, Skill Development and Entrepreneurship, Nagaland, Kohima. The challenge to the various, the challenge to the proceedings before the Nagaland Lokaयुक्त by the petitioners in WPC number 3/2005 is on the basis that in view of section 9 read with the second schedule of the Nagaland Lokaयुक्त and Upalokaयुक्त
Nagaland Lokaयुक्त Act 2017.
Act 2017. The Nagaland Lokaयुक्त could not have entertained such complaint. And as such, the complaint, the orders, as well as the letters which have been issued by the Nagaland Lokaयुक्त was put to challenge. Furthermore, as it was on the basis of the recommendation made by the Nagaland Lokaयुक्त, the petitioners in WPC number 3/2025 were terminated. That too without issuance of any show cause notice. The termination orders have also been put to challenge. Next. The writ petitioners in WPC number 3 the writ petitioner, Mr. Jamil, the writ petitioner in WPC number 3 is the writ petitioner in WPC number 17?
Yes.
Same. Or one more? Same.
18 is different.
The writ petitioner, first up, next. Upon filing of WPC number 3/2025, the records reveal that the impugned order of termination dated 7/1/2025 was stayed by this court. It further appears that pursuant to the stay granted to the impugned order of termination, the termination order dated 7/1/2025, by which the writ petitioners in WPC number 3/2025 were terminated, was withdrawn by the state of Nagaland. Full stop. It further appears that immediately thereafter, show cause notices were issued to the petitioners in WPC number 3/2025 as to why the services of the petitioner should not be terminated. These show cause notices have been assailed by the writ petitioners in WPC number 3/2025, in WPC number, by filing another writ petition being WPC number 17/2025. Next. The writ petitioner in WPC number 18/2025 was also issued a show cause notice on 22nd of January 2025 as to why the services of the said writ petitioner should not be terminated, as the petitioners was appointed without following the due process in terms with the recommendations from the Nagaland Lokayukta and the PNR department. The records reveal that all the three writ petitions were taken up together by the learned single judge and by the impugned judgment and order dated so and so.
24/11/2025.
In the three writ petitions, the learned single judge opined that the Nagaland Lokayukta had the jurisdiction to decide on the question, decide on the complaint, as the complaint was made by a third party, and as such, it would not come within the bar of Section 9, read with the second schedule of the Nagaland Lokayukta Act 2017, for short, the Act of 2017. The learned single judge also opined that the petitioners could not show that the opinion given by the Nagaland Lokayukta was perverse. First, the learned single judge also opined that there was no necessity for interference to the show cause notices so issued to the petitioners in WPC number 17/2025 as well as WPC number 18/2025. In addition to that, the learned single judge permitted the petitioners in WPC number 17/2025 and WPC number 18/2025 granted liberty to submit replies within 30 days. And with a further direction that the said replies would be considered in terms with the order dated 16/7/2024 passed by the Lokayukta Nagaland.
Nagaland Lokai.
Nagaland. First, being aggrieved, the present three appeals have been filed. Mr. Angami, tell me one thing. Whatever may be the recommendations, you cannot throw him out unless you comply with 9.
Yes, yes, under the disciplinary rules.
In fact, your show cause notice is not
Yes.
proper.
Yes, yes, correct, correct.
We need to interfere with your show cause notice,
Lordship.
giving you liberty to go ahead.
Yes, as per the rules.
Because you see, your show cause notice otherwise has a big problem. It categorically mentions that in terms with the recommendation.
Yes, correct, correct.
So therefore, we interfere with the show cause notice, but give you the permission to go ahead based upon the materials.
Correct.
You may have those materials, but don't rely on the materials.
Lordship.
Don't rely on the recommendation,
Yes.
but based on the materials.
I wish that he referred to the recommendation.
Huh?
I would wish that he referred to the recommendation.
Now they're also wiser.
Just let us come back in 5 minutes. These are the people who are there, all the petitioner, page 75 of rate appeal number 41. These are the petitioners.
Yes, Lordship.
Mr. We do one thing. We say that a recommendation so made without bringing you, without issuing notice to you, have impacted your right because you had a right to be heard before the locality. We don't set aside the local recommendation otherwise. because of the fact that the recommendation has something which action can be taken against those officials. That's a different thing. But these recommendations cannot be applied against you on the ground that you were not, on the ground that the principles of natural justice has been violated. Because what we can see that you were beneficiaries. What was being looked into is of those persons concerned. There were some illegalities committed by those persons. And this is the finding. So we only say that these recommendations which are there have been made without following the principles of natural justice against you. And as such, these recommendations cannot be made applicable to you.
Lordship, another aspect, suppose, going by that, what Lordship is proposing. If I subjected and submit to the jurisdiction, when you do not have the jurisdiction.
No, no, no,
So
no.
it will amount to admitting to the jurisdiction.
No, what we can say is this, as I could read the report out here, the report, the complaint was not made for you. It was said that this particular person had appointed many 10, 12 persons as MTS at a time when there was a ban. They could not have appointed. And it is that person concerned who have done.
Yes.
Against him, the action was taken. The fallout of that was that the Nagaland Lokayukta duly considered that aspect and said that these are the ban which was there. And at that point of time, this person could not have appointed these persons. There was no advertisement, nothing. Out of the 10, 12, one was appointed on compassionate basis. The other was appointed with some government approval. However, there is no date. But as regards this 9, they found nothing. And as such, as these are all illegal appointments made by that A, so therefore recommendation that they should also be terminated. This is the recommendation. But in that process, what has happened is you have been affected.
Yes.
So you have been affected, so you cannot be affected without giving you an opportunity of hearing. So that on that basis, we hold that the recommendations cannot be applied qua you. That is what you want.
Lordship, the challenge made before the learned single judge was that in a matter like this, considering the complaint, the nature of the complaint, because the complaint was to the best of our knowledge, one of the landowners who was not considered for appointment to one of the posts. He had a grievance, so he lodged a complaint. And then investigation took up by taking cognizance under complaint. Our case was, look, in view of part under section 9 of the Nagaland Lokayukta Act, read with second schedule, the Nagaland Lokayukta do not have the jurisdiction to investigate in such a matter. So under section
Let us
2,
see that. Because if we go into that, why it is not there? It is put it here, no?
it starts from 120. Now,
Except as hereinafter provided, the Lokayukta shall not conduct an investigation under the Act in cases of complaint involving grievances in respect of any action. A, if such action relates to any matter specified in the second schedule, or if complainant had or had any remedy by way of proceeding before any other forum or authority, provided that nothing in clause B shall prevent so and so from conducting, if the Lokayukta as the case satisfied that such person could not or cannot be sufficient cause have recourse to here. Lokayukta or so and so shall not investigate any action in the form of a formal and a public action or so and so. Any person in respect of any action in respect to which has been referred, Lokayukta shall not have any complaint, grievance after the expiry of the period of 12 months limitation. here involving an allegation made after the expiry of.
Second schedule, D will be relevant.
D,
D.
action
Page
taken
122.
in respect of appointment, removal, or relating to conditions of service of public servants, but not including actions.
Appointment being and conditions of service, this are part. Because the object of law is to check
The specific.
the corruption in the high levels. More particularly.
Let us see the act.
politicians.
Let us see the act because of the fact that here there are a lot of typing mistakes in the implement.
The very object of law is for preventing the corruptions that may be committed under the Prevention of Corruption Act. Lordships are aware about the objects of the Prevention of Corruption Act. So whom it is applicable.
What do you mean by D? Let us understand D. Action taken in respect of appointments, removal, pay, discipline, superannuation, or other matters relating to condition here, but not including action means relating to
the
claims
claims for pension, gratuity, provident fund. Or
so
retirement.
these matters can be taken up.
Yes,
They can
First
take up
part-
pension, gratuity and
Yeah.
all, but
Yeah.
cannot take up any action in respect of appointment.
yes. In short, Lordship, to understand in the shortest and simplest way. If a complaint is lodged with a grievance, then no investigation. But if an allegation is made by a third party, mere allegation, such cases can be investigated by the local
How? Under what provision?
under section 10 laws. It has made a distinction between two. A grievance involving a complaint involving a grievance and a complaint involving a grievance. A coordinate bench of this honorable court has also passed an order explaining about that, Lordship. Just for a quick reference, Lordships. The similar issue was raised. Paragraph 16 will be relevant, Lordship, after discussing the provisions. Paragraph 16. I have lost in this case, but then it turns to be beneficial for the other cases, Lordship. In the writ petition, I succeeded, but in the writ appeal. It was reversed.
Read this again, the problem, it is only when a party who is aggrieved by an action pertaining to any of the matters mentioned above that such a complaint is barred under section 9. The said bar, however, cannot be extended to an allegation by a third party.
Yes,
And in the instant case, it is not in dispute that the allegation is by a third party and not by the writ petitioners pertaining to do with their service conditions. Meaning thereby,
if a third party makes a complaint to the Lokayukta, making some allegations, but the complainant do not have a grievance at all, then in that case, it can be investigated. But what the learned single judge has arrived in our case is that it is not a complaint by the petitioners, and there is no grievance. So it can be investigated, but
learned single judge held it to be a third party.
he arrived to the conclusion that it is a complaint by the third party,
So
but
then the bar under, if we go by this, then the bar under 9 is not there.
Lordship, if the complaint is involving a grievance, then there is a bar. So a copy of the complaint will be necessary, whether it is a grievance or not. But our information goes that one of the landowners who was claiming for appointment was not given appointment. So he lodged the complaint, alleging a grievance that you should have considered by. So without having that document, the learned single judge has arrived to a finding that it is by a third party. From where the learned single judge has arrived to the conclusion that there is no grievance. Whether there is a grievance or not, it should be ascertained from the complaint itself. And that complaint can be produced by the Lokayukta because they are the custodian of the records. And we have filed an RTA application to the Lokayukta. Please furnish a copy of the complaint. But that was declined on the ground that the Whistleblowers Act is applicable. So we cannot furnish a copy of the complaint.
No, kindly see, subject to the provisions of this act, a complaint may be made under this act to the Lokayukta. Semicolon. In the case of an allegation by any person, and in the case of a grievance by a person aggrieved. Provided that where the person aggrieved is dead or for any reason unable to act for himself, the complaint may be made or continued by his legal representative or by any other person who is authorized by him in writing in their behalf. No, you see, we have to understand. Section 8 provides a power upon the Lokayukta to investigate certain matters.
Yes.
Section 9 says matters not subject to investigation. But interestingly, section 9 starts with except as hereinafter provided. The Lokayukta or the Upalokayukta shall not conduct an investigation under this act in the cases of complaint involving a grievance if any action. So these are the actions where the Lokayukta would not, except as hereinafter provided. This word has a meaning. Means if it is hereinafter, not in this, it has to be subsequent to the other provisions.
So,
Although it appears that it should not have, it should have started with it and have 1, 2, 3, 4.
so
The
it
act
will- yes.
appears to be in that manner. It should have been except as hereinafter provided, the Lokayukta so and so shall not conduct the Iman as so and so. So here, 1, 2, 3, 4, all these
Now-
things the Lokayukta would not.
Yes, A will have a connection, direct connection with second schedule. So when by the second schedule, this is with regard to the appointment
Yes. Now therefore,
and it is a service matter.
no, understood. So here Lokayukta would not. The word starting, therefore, the word except as hereinafter provided means that all these other things,
Can be
no,
investigated.
Lokayukta cannot, which is mentioned out there. But except what is hereinafter provided means anything provided after section 9. Meaning thereby, section 10 is an exception to section 9.
When by section 10, there are two complaints. One, an allegation, and the other is grievance. If it is with a grievance, then no.
Why?
But
No, why do you say no?
because there is a part under section 9,
No. Section 9 is different. Therefore, I'm saying the word except is hereinafter provided. And thereupon, what is being mentioned that the Lokayukta shall not do it. Means the Lokayukta can, but not these. You see, the language appears to be something, some mistake is there.
It's it may be. When it can be a negation or can be a grievance. So if it's negation, it may be.
third party can do it. So that is not the issue. What it appears is except is hereinafter provided. This term has relevance. Normally, when you have this act, well, you see a lot of acts, you see, this should have been, it should start with except as hereinafter, where the Lokayukta shall not. And then you come up with ABCD. But here they have joined it with one. The word except as hereinafter provided means the Lokayukta can, but not these. Where it can will come you to 10.
and section 9 is also interpreted by this honorable court in the other judgment.
That is what
Which
I'm saying.
place?
Yeah, therefore it says. Therefore I'm saying. It is only when a party who is aggrieved by an action pertaining to any of the matters mentioned above that such a complaint is barred under 9.
Therefore, it will be relevant to see what is the content of the complaint, whether it is with a grievance or not. And without a copy of the complaint, the learned single judge has arrived to the conclusion that it is an allegation only. So not involve a grievance. Whether it is involving a grievance or not, only by reading the copy of the complaint will know. That is my case, Lordship. Yeah.
No, if you see page 48, the Nagaland Lokayukta received a complaint filed on Iman against the Department of Employment and so, alleging bogus appointments were made to 12 so for brevity hereinafter MTS in the year without obtaining an in violation of Iman procedure, and further that the appointments were made prior to lifting of the ban. This is the scope of the appeal. This is a case of a complaint.
But this is the finding of the Lokayukta.
This is not a finding. This is the starting. It's an introduction. Finding is there in the conclusions. But we will then also help you out on that aspect, that these recommendations cannot be taken against you, taking into account the principles of natural justice. Mr. T.B. Jamir, you are there. You normally appear for Lokayukta. Now tell me one thing.
Bill before lordship, it's on into section 9. That has been guaranteed by a division bench of the local court in beautiful one of them.
1 of 24.
So this.
It is-
This is one.
Beautiful one.
Now that I've looked into. No, that I've looked into. Although we have, I don't know what my sister says. I have a difficulty to say only to limit it to the grievance. Grievance a person would not, but a complaint it would be. Because you see a reading of section 8 and 9, you have to understand 8 is what the matters the Lokayukta can look. It can look into those matters which are being forwarded. 8 says forwarded.
And so much also is there.
No, Sumuto is there, but 8 says forwarded. Finally, see, subject to the provisions of this act, the Lokayukta may investigate an action which is taken by or with the specific approval of these. So this is, you can take, has the approval taken by and with the, or with the general or special approval of the year. Meaning thereby either there has to be a general or special, or which is taken by or with the, means it has to be with this approval of these. May, if it thinks fit, investigate an action taken by or with the general approval of a public functionary if it is referred to him. The law may, for reasons to investigate any action which may be investigated by so and so, whether or not the complaint has been made to the Lokayukta in respect of such action. So it can do so. So 8 says these are the powers. Either it has to be referred or it can take it on its own. But 9 says,
Exception.
9 is an exception, but 9 starts with the word except as hereinafter provided the Lokayukta cannot. Meaning thereby, what is mentioned subsequently, the Lokayukta can.
Can.
Assam, Lokayukta and Upalika Act of 1985, similar provision is just section 8 and the third schedule G. In fact, all Lokayukta Act similar provisions are there, your worship. Now, so far as interpretation of this section is concerned, your worship, when the matter was taken, I said, my submission would not be at this field. Just because it needs to be jurisdiction of Lokayukta must be rightly interpreted by this. That was my submission. And accordingly, that was their meet your worship, we take no other. In fact, as I said, Assam or other states have not ever your worship.
No, I'm not that. But Mr. Dami, one thing. The moment you are deciding somebody's fate by making a recommendation, don't you think that the Lokayukta also requires of natural justice?
I think section 12 is the, this one on this filter. It is there. Yes, if I'm not.
In doing so, the principles of natural justice. So therefore, 12 appears to be have been violated because these people have not at all been taken into consideration. So, but the recommendation, we should not touch it otherwise because it touches upon a particular person. He is not before us. He is not before us. Why should we touch on that? But these recommendations cannot be made applicable against them, taking into account the spirit of section 8B and 8C of the Commission of Inquiries Act. Because these are basic format. These are basic procedural safeguards. which are given out there. So I think this is the best order because they have to comply with natural justice. Sure. We have heard the learned counsels appearing on behalf of the parties and have given our anxious consideration. A perusal of the materials on record show that the Nagaland Lokayukta received a complaint filed on 10/10/2022 against the Department of Employment, Skill Development and Entrepreneur, alleging that bogus appointments were made to 12 posts of multitasking staff (MTS) without obtaining the government approval, in violation of the laid down government procedure regulating such appointment, and further that the appointments were made prior to lifting of the ban on such appointments. On the basis of the said complaint, a preliminary inquiry was conducted by the Nagaland Lokayukta on 12/10/2022, and a progress report was submitted on 12/12/2022 by the investigating officer of the Nagaland Lokayukta Police. By an order dated 1/2/2023, the learned Lokayukta issued directions upon the Department of PNR to furnish information on the action taken for giving approval to the Department of Employment, Skill Development and Entrepreneur as per the established procedure, and whether advertisements for open recruitment have been done away with in the case of the appointment of the post of MTS. By a communication dated 3rd of April 2023, the PNR wrote a letter addressed to the Commissioner and Secretary, Employment, Skill Development and Entrepreneur, to clarify whether the approval of the AHOD was taken in the file before the approval was issued by the Undersecretary so as to determine if the action may be recommended against the AHOD or the Undersecretary or any other erring official as the case may be. In continuation to the said communication dated 3rd of April 2023, the PNR department wrote another letter dated 23/8/2023 addressed to the Commissioner and Secretary, Labor and Employment Skill Development Entrepreneur, requesting to submit all the relevant correspondences /files related to the administrative approval given in the appointment of 1 MTS and 8 numbers of posts and 8 MTS posts. Subsequent thereto, the additional secretary and the ex officio director (HOD) Labor and Employment Skill and Development Entrepreneur submitted a reply with documents to the Nagaland Lokayukta of Police. In the said communication, it was clarified it was informed that number one, appointment orders were issued to 10 posts of MTS and not 12. Number two, out of the 10 MTS appointments orders, one MTS was appointed on compassionate ground with the approval of the government, dated 17/6/2022. Number three, one post and the remaining 8 posts MTS were appointed on the basis of an approval by the government letter dated 6/4/2022 and 5/5/2022 respectively. Number 4, no advertisements were made in the daily newspaper for the MTS force. And number 5, department screening committee was not constituted. It further appears that based upon these communications, it further appears that the Nagaland Lokaयुक्त thereupon perused the materials and made further inquiries and found that the appointments so made found that the action of the officials involved in the complaint appears to be more in the nature of misconduct and violation of the government instructions and the provisions of the Nagaland Government Servants Conduct Rules 1968. The Nagaland Lokaयुक्त further had taken into consideration the Office Memorandum dated 3/3/2022 and opined that there was no partial lifting of the ban as conveyed in the letter of the government approval. Based upon the investigation so carried out, the learned Lokaयुक्त provided its findings and recommendations in the order dated 16/7/2024, stating inter alia that the allegations made in the complaint dated 13/9/2022 were proved to be true on bogus appointments of 9 MTS and not 12 as alleged. In the same recommendation, it was also mentioned that the appointment of the 9 persons and then appointment of the 9 appointments made to the post of MTS were null and void in the eye of law. it was also stated, it was also recommended that in the light of the findings, the competent authority of the Department of Labor and Employment, Skill Development and Entrepreneurship to terminate the appointment of 9 illegal appointees by following the due process of law, which is issuing a show cause notice as to why the appointment should not be terminated, as the appointment did not have the sanction of law. It further appears that in pursuance thereto, the petitioners in WPC number 3/2025 were terminated by a communication dated by the order of termination dated 7/1/2025. This termination order dated 7/1/2025 was made even without issuance of any show cause notice, though in the order dated 16/7/2024 by the learned Nagaland Lokayukta, there was a recommendation for issuance of a show cause notice. First, upon the writ petition being WPC number 3/2025 having been filed, and a stay granted to the order of termination dated 7/1/2025, it appears that the state respondents thought it prudent to withdraw the termination order dated 7/1/2025. Accordingly, the impugned order dated 7/1/2025 was withdrawn during the pendency of WPC number 3/2025 and subsequently on 22/1/2025 show cause notices have been issued to the writ petitioners in WPC number 3/2025, as well as the writ petitioner in WPC number 18/2025. It is under such circumstances both the writ petitions, being WPC number 17/2025 and WPC number 18/2025 has been filed. Let us first look into as to whether the Nagaland Lokayukta had the authority to decide to investigate the complaint dated 30/9/2022. In as much as it is the specific case of the petitioners that the Nagaland Lokayukta did not have the jurisdiction to do so, taking into account Section 9 of the Act of 2017, read with the second schedule, more particularly Clause D of the Act of 2017. We have perused the Act of 2017, which was enacted for the purpose of conducting investigation and inquiries full stop. Section 8 of the Act of 2017 stipulates the matters which may be investigated by the Lokayukta or the Upalokayukta. A perusal of subsection 1 and subsection 2 of section 8 reveals that a Lokayukta may investigate any action which is taken by or with the general or specific approval of the chief minister or the minister or the secretary, a member of the state legislature, semicolon, vice chancellor or registrar of a university, the chairman and semicolon, the chairman and the vice chairman or member of an authority, comma, board or committee, a statutory or non-statutory body or a corporation established by or under any law of the state legislature, semicolon, any other public servant, as well as with the general or specific approval of a public functionary. It further appears from the reading of section 8.3 that the Lokayukta may, comma, for reasons to be recorded in writing, investigate any action which may be investigated by a Upalokayukta, whether or not a complaint has been made to the Lokayukta in respect to such action. This court now finds it relevant to take note of section 9. Which refers to matters which are not subject to investigation by the Lokayukta. Section 9.1 starts with the words except, inverted comma, except as hereinafter provided. Semicolon close. Inverted comma close. And proceeds with what the Lokayukta or the Upalokayukta shall not conduct, shall not investigate. It stipulates in clauses A and B of subsection 1 of section 9 what the Lokayukta or Upalokayukta shall not investigate. Section A, subsection, clause A of section 9.1 is of relevance inasmuch as it is the case of the petitioner that a Lokayukta cannot investigate in respect to cases if such action, in respect to matters, if such cases, such action relates to any matter specified in second schedule. We have taken note of the second schedule. which is specifically relates to section 9(1)(a) of the Act of 2017. It includes various type of actions which the Lokayukta cannot investigate. And in terms with clause D of the second schedule, action taken in respect of appointments, removal, pay, discipline, superannuation, or other matters relating to conditions of service of public servants cannot be taken up for investigation by the Lokayukta. For the sake of clarity, we like to observe that claims for pension, gratuity, provident fund, or any other claim which arise on retirement, removal, on termination of service, and such other actions involving allegations of corruption in respect of appointment is not barred under the provisions of section 35 of the Act. So allegations of corruption is there. Isn't it, Mr. Angami?
Yes.
Allegations of
Yes,
corruption in
yes,
appointment can be
yes,
looked into.
Correct.
If there is any corruption, involvement of any corruption, that will be the persons who has committed,
Yes,
Yes.
not the petition.
yes. So this is therefore within its scope. Taking into account the importance of clause D to the present dispute, we reproduce clause D of the second schedule. From the above quoted clause, it is apparently clear that when it relates to allegations of corruption in respect to appointment, the bar contained in section 9(1)(a) of the Act of 2017 would not apply. We also find it relevant to take note of section 10 of the Act of 2017. Section 10 has relevance taking into account the opening words of section 9(1). That is, except as hereinafter provided, inverted comma. A perusal of section 10(1) stipulates that a complaint may be made under the Act of 2017 to the Lokayukta in the case of an allegation by any person and in the case of a grievance by a person aggrieved. The proviso to section 10(1) relates to the continuation of an investigation into a grievance of a person aggrieved, even upon his death through his legal representative or by any other person who is authorized by him in writing in their behalf. In the backdrop of the above, if this court now recapitulates the facts as already delineated here in above, and more particularly the complaint which was filed on 39/2022, 39 or 10/10? 10/10/2022. It is a complaint pertaining to the allegation of corruption, which is not barred in terms with Section 9(1)(a). In view of the exception mentioned in Clause D of the second schedule to the Act of 2017. Further to that, we are inclined to observe that the learned single judge was also right in observing that the bar contained under Section 9 as well as the second schedule shall not apply in respect to a third-party complaint as is conceived under Section 10 of the Act of 2017. We are therefore of the opinion that the first grievance of the petitioners or oblique the appellants herein to the effect that the petitioner, that the respondent, that the locator had no jurisdiction to entertain the complaint on 10/10/2022 and make recommendation, entertain the complaint is liable to be rejected, is rejected. We come back, give the sentence.